An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman.
Sherbert versus Verner, 1963. Employment Division versus Smith, 1990. And Church of the Lukumi Babalu I versus City of Hialeah, 1993. The First Amendment begins, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The last portion of these provisions is referred to as the Free Exercise Clause. The cases in this topic all concern the same underlying issue. What happens when the government burdens conduct that is part of someone's religious practice? Specifically, does the Free Exercise Clause allow the judiciary to create an exemption to such laws? In the first case, Sherbert versus Verner, the Supreme Court created such an exemption. Adele Sherbert's employer told her to work on Saturdays. Sherbert, a member of the Seventh-day Adventist Church, declined that assignment. She celebrated the Sabbath on Saturday instead of Sunday. As a result, Sherbert was fired. Subsequently, South Carolina denied her unemployment benefits because she was unwilling to work on Saturday. Sherbert's attorney explained her position to the court.
She was willing to work and able to work in any mill or in any other industry, so long as the job was a decent job, and so long as it did not require her to work on her Sabbath.
The court ruled for Sherbert by a 7-2 vote. Justice Brennan wrote the majority opinion. The court found that the state's decision to disqualify Sherbert for benefits, quote, imposes a burden on the free exercise of her religion. The government put, quote, pressure upon her to forgo her religious beliefs in order to receive employment benefits. Furthermore, the court found that South Carolina did not have a compelling state interest that, quote, justified the substantial infringement of appellate's First Amendment right. It was not enough to assert that, quote, unscrupulous claimants feigning religious objections to Saturday work might file fraudulent claims. Indeed, even if such a problem existed, the state would have, quote, to demonstrate that no alternative forms of regulation would combat such abuses without infringing First Amendment rights. In this case, there was no evidence that the state enacted or enforced its law with animus towards Sabbatarians. Rather, the law was generally applicable. It applied equally to people of all faiths. Nevertheless, the court held that the Free Exercise Clause required South Carolina to exempt Sherbert from the usual requirement of its unemployment laws. This framework came to be known as the Sherbert test. If the government imposed a substantial burden on the free exercise of religion, the state must demonstrate that its law is the least restrictive means to achieve a compelling state interest. If the state interest is not compelling, or if there was another less restrictive means to accomplish that interest, the state must avoid imposing a substantial burden on the free exercise of religion. In our next case, Employment Division versus Smith, the Supreme Court would limit, if not effectively overrule, Sherbert. Al Smith lost his job as a drug abuse counselor due to his use of peyote. He ingested that hallucinogenic cactus during a ritual in the Native American church. Oregon denied Smith unemployment benefits because he was discharged for work-related misconduct. That is, using an illegal controlled substance.
The issue currently before us is whether Oregon's criminal law against the use of certain mind-altering drugs, including peyote, can constitutionally be applied to the respondent's sacramental use of peyote in ceremonies of the Native American Church.
The court ruled against Smith. Justice Scalia wrote the majority opinion. He explained the Free Exercise Clause
prevents the government from penalizing adherence to a religious position or the profession of a religious belief. It also prevents the government from penalizing an action only because that action is taken for religious reasons or only because of the religious beliefs that action displays.
However, the court found that Smith's request for an exemption did not fit with its line of cases, including Sherbert.
Respondents seek to carry the meaning of prohibiting the free exercise of religion one large step further. They contend that a religious motivation for engaging in legally prohibited action or for failing to take legally required action places the citizen beyond the reach of a law that is not specifically directed at his religious practice and that is concededly constitutional as applied to others. We reject that interpretation.
Why was Smith's situation different from that of Sherbert?
Respondents' contention that our precedent requires a religious practice exemption to generally applicable laws is mistaken. A long line of our decisions has held that an individual's religious beliefs do not exclude him from compliance with an otherwise valid law prohibiting conduct that the state is free to regulate. For example, laws prohibiting polygamy, laws regulating the use of child labor, laws requiring individuals to perform military service, and laws compelling individuals to pay taxes.
Oregon prohibited all people from using peyote. In contrast, South Carolina did not, and indeed could not, prohibit people from celebrating the Sabbath on Saturday. Study Guide. Do you find this distinction between Sherbert and Smith persuasive? Recall that under the Sherbert test, the state had to demonstrate a compelling state interest in order to justify substantially burdening the free exercise of religion. The Smith court rejected that framework.
We reject respondents' argument that governmental actions burdening religion must be justified by a compelling governmental interest. The government's ability to enforce its criminal laws, like its ability to carry out other aspects of public policy, cannot depend on measuring the effects of a governmental action on a religious objector's spiritual development. Open the prospect of constitutionally required exemptions from civic obligations of every conceivable kind.
Justice Scalia admitted that in other words, majority faiths would be able to achieve exemptions through the democratic process. During oral argument, Justice Stevens asked if the state could
to outlaw totally the use of alcohol, including wine in religious ceremonies.
The attorney for Oregon answered,
there might be a religious accommodation argument of an entirely different order than is presented here.
Justice Stevens responded,
so you mean it's just a better-known religion?
Ultimately, Justice Scalia found this inequity, quote, unavoidable consequence of democratic government that must be preferred to a system in which each conscience is a law unto itself, or in which judges weigh the social importance of all laws against the centrality of all religious beliefs. The court refused to create an exemption to a generally applicable law that burdens the free exercise of religion. In such cases, the government no longer needed to demonstrate that its law is the least restrictive means to achieve a compelling state interest. Smith proved to be extremely unpopular across party lines. Several years later, Congress sought to reverse its effect and restore the Sherbert test. In 1993, President Clinton signed into law the Religious Freedom Restoration Act, which passed Congress by a huge bipartisan majority.
We all have a shared desire here to protect perhaps the most precious of all American liberties, religious freedom.
We will study RFRA in a future video. Under Smith, the court reviewed generally applicable laws that burden religion with a deferential form of rational basis review. Our next case examined whether a law truly applied generally to all religions or whether it targeted a single faith. Church of Lukumi Babalu I versus Hialeah involved the Santeria religion. Members of this religion perform animal sacrifices. The attorney for the church, Professor Douglas Lakehart, described this ritual.
To believers in Santeria, sacrifice is directly commanded by the gods in considerable detail on each occasion when it is required.
A new Santeria church was planned to open in the city of Hialeah, Florida. Members of the Hialeah community were disturbed because the Santeria performed animal sacrifices. The lawyer for the city explained,
"The animals were being, in effect, tortured in Hialeah and subjected to cruel treatment in the form of possession prior to sacrifice. When sacrifices take place, as many as 52 animals in a single day are killed. And then they are decapitated, blood is put into pots. The animals are then oftentimes left out in public places if there is a ritual that requires the animal to be left in a public place.
In response to this practice, the city prohibited sacrificing animals, quote, in a public or private ritual or ceremony not for the primary purpose of food consumption. However, licensed establishments could slaughter animals that were, quote, specifically raised for food purposes. The church argued that Smith's rational basis review was not appropriate because the law was not generally applicable. It only targeted the Santeria religion.
This is a case about open discrimination against a minority religion. They were enacted for the express purpose of preventing the central rituals of this faith.
The court unanimously ruled in favor of the church. Justice Kennedy wrote the majority opinion. He explained why the Smith test did not apply. Quote, neutrality and general applicability are interrelated, and as becomes apparent in this case, failure to satisfy one requirement is a likely indication that the other has not been satisfied. A law failing to satisfy these requirements must be justified by a compelling governmental interest and must be narrowly tailored to advance that interest. In other words, the Sherbert test still applied if the law was not neutral or generally applicable. Based on the record, Justice Kennedy found that, quote, suppression of the central element of the Santeria worship service was the object of the ordinances. Critically, quote, the legitimate governmental interest in protecting the public health and preventing cruelty to animals could be addressed by restrictions stopping far short of a flat prohibition of all Santeria sacrificial practice. For example, the city, quote, could have imposed a general regulation on the disposal of organic garbage. The ordinances failed strict scrutiny because the city did not adopt the least restrictive means to accomplish its purpose. The court concluded, quote, legislators may not devise mechanisms, overt or disguised, designed to persecute or oppress a religion or its practices. The laws here in question were enacted contrary to these constitutional principles, and they are void.